be available on the Backtrack website. And if you have any questions during the webinar, please type them in the control panel and we'll answer them at the end. So now I'll turn it over to you, John. Thank you.
Great, thank you very much. Thank you all who made it today back for attempt number 2 at talking about workplace social media. Hopefully we have all of our technical glitches that those of us who were here last week experienced worked out. I think we do. And so with that, we're going to move right in. For those that weren't here last week, we got about, I don't know, maybe 15 minutes into the presentation, and so some of this may sound very familiar, and I promise you it's not a recording. This is live, but for those who were not with us last week, I am going to kind of start from scratch and run through from top to bottom. And so we're going to be talking about the legal issues surrounding kind of what your employees do online when they're in work and not in work. But before we do that, I want to start with a story. And the story involves a woman by the name of Heather Armstrong. And the story starts all the way back in 2001 when Heather Armstrong was working at an internet startup in Southern California. Today, Heather is known for those that read mommy blogs as the queen of the mommy bloggers. Her blog is deuce.com, and she writes today about what's going on in her life, her kids, her divorce, her dogs, being a stay-at-home mom who writes a blog full-time, whatever. I mean, that's what she writes about. She writes about her life. That's 2016. All the way back in 2001, when Heather was not a mommy blogger, was not a mom, was not a divorcee, was not a wife, was not, she was a 20-something single white female living in Los Angeles, and she wrote about what she knew, and a lot of what she wrote about was her job. She wasn't Heather Armstrong blogger at the time. The blog was just deuce.com. It was written anonymously. But she wrote about work, and so some of the things she wrote about were she didn't necessarily paint her workplace in the most attractive light. So she wrote about unflattering stereotypes about some of her Asian coworkers. She wrote about some of her coworkers' bathroom habits. She wrote about how she would blow off work and leave work in the middle of the day and drive around Los Angeles with her top down or go home and go to sleep when she should have been working, what have you. And Deuce.com picked up some traction, got a little popular in Southern California, and one of her coworkers put 2 and 2 together, figured out that the workplace that was being written about was this particular workplace, and further put it together that Heather Armstrong was the person that was authoring this blog, was the author of this blog. And this is the blog post that Heather Armstrong wrote on February 26, 2002, the day that she got fired. And she wrote, and you all can read along at home, that she called the blog post Collecting Unemployment, and she wrote, I lost my job today, my direct boss, and the human resources representative pulled me into one of 3 relatively tiny conference rooms and informed me that the company no longer had any use for me. Essentially, they explained they didn't like what I had expressed on my website. I got fired because of Deuce.com. She continued down at the bottom. 2 weeks ago, an anonymous person emailed every vice president of my company to inform them that I had written unsavory things on my personal website. And then she continues on to ask 3 questions of her readers. And we need to keep in mind that you kind of need to go in your own little personal time machine and go back to 2002. And some of these questions now seem like pretty obvious questions to ask. In 2016, when we live in a world, as we'll talk about in a minute, dominated by Facebook and Twitter and Snapchat and LinkedIn and blogs and everything else. But in 2002, there was no Facebook, there was no Twitter, there was no Instagram, there was none of this. We had the internet, we had websites, but we didn't have the social net as we understand it, and we'll talk about in a minute, just flat out didn't exist. And so think, as you read these questions, think how how much foresight Heather Armstrong had when she asked them all the way back in 14 years ago, February 2002. Number one, should I lose my job over what I've written on my personal website, especially if I have made sure not to mention specific places, persons, or events by name? Number two, at what point does my personal website, regardless of what I've published on the site, affect my professional life? And number three, what recourse do I have? And we'll spend some time over the course of the next 55 minutes, give or take, talking through, not specifically, but talking about the answers to these three questions. Heather continued with some advice for employees everywhere. Her advice was, be ye not so stupid. Never write about work on the internet unless your boss knows and sanctions the fact that you are writing about work on the internet. Let me suggest that if employees heeded this advice, I would have a different job. I at least probably wouldn't be, I certainly wouldn't be an employment lawyer. I might not be a lawyer at all, because employees, as we're going to see in a minute, do, out of a misbelief, either that their company won't find out or that what they do when they're not at work doesn't impact what they do, or doesn't impact their jobs, just do really, really, really stupid things behind what they perceive as a cloak of invincibility that the internet provides. Big misperception. Deuce.com, for those that read the Urban Dictionary, has entered the lexicon as a terminology that people use. So deuce has now become, from Heather's deuce.com, has now become a verb to lose one's job because of one's website. All of which really begs the question, John, it's a great story, it's interesting, talking, drawing the parallels between 2016 and what happened to Heather Armstrong back in 2002. Why should we as businesses care? This is the results of one survey question from a larger survey done by Proskauer Rose, big international white shoe law firm that surveyed thousands of its clients. This was the third such survey it did back in 2014, asking many, many questions about the role, the intersection of technology and work. But the one question I want to focus in on was whether the misuse of social media was an issue that your business has ever had to deal with. And it's interesting to kind of track this over time to kind of see where we're going. So 2012, almost 46%, 45.9% said, yeah, misuse of social media is an issue that we've had to deal with. That was in their 1.0 survey. Flash forward a year to their 2.0 survey. 2011, 43%. Flash forward a year to 2012, 45%. Then the last survey they did, 2013, 2014, we now see that orange line kind of crest past the 6 o'clock line, and so we're now at a little over 52%. They have not, I checked again this morning, they have not yet released version 4.0. I don't even know if there's going to be a version 4.0 in this survey. I hope there is, because it's interesting, again, to track this stuff over time. I would venture to bet that if a survey, the same question was asked of those same companies today, as to their experience up through 2015, I would venture to bet that we would see that orange line much closer to 9 o'clock, if not past the 9 o'clock line, if not way past the 9 o'clock line, because I find it hard to believe, just in my own personal experience with the clients I deal with, that there is not a business out there that employs people that use computers that has not had to deal with this as an issue. And it's easy, when we look at the statistics, we can understand why so many businesses have dealt with kind of misuse of social media as an issue with their employees. I don't want to beat the stats over the head, because they are, we understand how large these social networks are, but I think it's important, nevertheless, to kind of just take a snapshot of kind of, so you understand just how massive these are. Facebook, 1.5 billion users. almost 850 million of them connecting mobily, and we're going to talk in a little bit about why that's so important. Depending on the day of the week, it's either the number one or number two most popular website measured just purely by traffic, how many people go there on a given day. Twitter, number 8 by traffic. They say more than 1 billion users, more than 100 million of them active on a monthly basis. And again, just massive amounts of users, of Twitter users accessing the website, not just from their desktops, but also from their mobile devices, 80% of that 1 billion users. LinkedIn, not quite as big as Facebook and Twitter, but still, close to 400 million total users, and still close to half accessing it mobily. What's the most interesting stat to point out about LinkedIn, and again, we'll talk about this in a moment as to why it's so important for you and your business, is that 94% of recruiters are using LinkedIn to vet job candidates, and we're going to talk in a little bit about the kind of how to do that properly without running into some unnecessary legal risks. That's just, the big three, as I call them, are just a piece of the social media puzzle. There is, an entire world of a universe of websites that we think of as social media. When Web 1.0 came out back in the 90s, we went to the internet to gather information. It was an information gathering tool. Now we go to the internet to share information. Web 2.0, social media. Really any website that you can go to that is not static information gathering, but rather interactive information sharing, falls under this umbrella of social media. So whether it's the big three like we talked about, Facebook, Twitter, LinkedIn, it could be music sharing via Spotify, it could be video sharing via YouTube, it could be blogs like WordPress or Blogger, it could be article sharing via or social bookmark sharing via websites or apps like Instapaper. It's anything that allows you to share information with other people via the internet is going to fall under this umbrella of social media. And just a couple of quick examples of how some employees got themselves in trouble with kind of the latest and greatest, although not necessarily the latest anymore, but certainly in terms of what has become popular. We think of photo and video sharing as kind of the way social media has moved and continues to move. This is an employee, a nurse, who got herself not just in trouble but fired for an Instagram photo she posted of herself at work. This L. Tonelli, whoever she is or wherever she is, put this picture up of herself and wrote "FU," #nurse, #tired, #healthcare, #hate my boss, #so sick of work, #need a break. As I said, the company obliged, gave her a break, and removed her from employment solely because of this picture that she took at work. Another example, this is King Leno 1620, again, whoever he is or she is, also on Instagram. And much like the nurse's post, again here the hashtags tell the story as to what we're looking at. Hashtag called in sick, hashtag my leg really hurt though, hashtag blocked my manager, hashtag I hope my coworkers don't rat me out, hashtag Sundays off. And much like the nurse before, this employee got his or her wish, not just with Sundays off, but with every day off, fired as a result of this Instagram post. Not just photos, but also videos. Instagram allows you to post videos of up to 15 seconds in length. Vine, which is owned by Twitter, videos of up to 6 seconds in length. And you may be asking yourself, or maybe not, geez, John, how much trouble can an employee get in 6 seconds? Excuse me for a second. This is a Vine post that an employee made. This employee flipping through a confidential slide deck. This employee, there she is, also relieved of her job as a result of this short, under 6 second video that she posted of herself flipping through her company's confidential information and putting it out there for the world to see on Vine. When we talk about the real cutting edge in terms of social media, we're talking about things like Snapchat, which I just read yesterday, crested over 1 billion users, which is staggering that there's 1 billion people using Snapchat. For those that are unfamiliar, Snapchat essentially allows you to send messages, photo messages that then have a self-destructing timer on them, so they self-destruct within a predetermined amount of time, where the photo then disappears from the app, from the device, and then becomes non-retrievable. From a what keeps me up at night perspective when I think of litigation and where you have allegations of maybe harassment, an issue we'll talk about later in the presentation, where the allegation is maybe the harassment took place via Snapchat. You now have evidence that is gone and will never be retrieved because of the what makes the app so attractive. That is the messages, the photos disappear within a predetermined amount of time once they're opened. Bottom half of the slide, Meerkat and Periscope are live video services. They essentially turn everybody into a video journalist. You just pull your phone out, turn it on, and you then from the comfort of your iPhone or Android device, have the ability to broadcast live video for the world to see. Facebook just last week completed its rollout of its own live video feature designed as a competitor to Meerkat and Periscope. And think about the implications of an employee live broadcasting for the world safety violations in your workplace, or an abusive manager, or live from a picket line, what have you. Very, very powerful tools that your employees now have in their pockets, at their disposal really all the time. When we think about the risk that these tools create, the risks really break down into what I think of as two very broad categories. You have brand management risks and brand management and risk management. So risk to your brand as an employer and to your employees' individual personal brand as a human being, and then the legal risks that come from your employees being on these social networks. I'm going to talk a little bit about kind of the brand management risks, but the bulk of what I'm going to talk about is how you manage the legal risks that come out of what your employees are doing on these social networks, both in work and out of work. When we talk about brand management, we talk about things like, Heather Armstrong's Deuce.com and, the impact to your brand when it's discovered that she's out there, blogging about what's going on in the workplace. The same thing happened to the Bitter Barista, who was also an anonymous blogger blogging from the coffee shop he worked at in Seattle, until he was outed as someone. He was de-anonymized, if that's a word. He was outed, brought to light who he was, and he was fired as a result of his blog, where he would write things about, as you see on the screen, in the slide, as to what was going on in his particular workplace. This is a more recent example. This is Erica Escalante, who was interning at a company. While in her personal time, she went cotton picking, and then decided to post our inner N-word came out today. This post went viral. She lost her job as a result. The company had to go into immediate damage control mode because the media linked her to the company for which she was employed, particularly after she was fired, and the company did a good job in damage control to its brand. Even though this post has since been deleted by Erica, she can't delete it from every news outlet that took a screen cap and published it. And so think of the damage to her personal brand as a result of every time someone Googles her name, forever and ever and ever, this is what they're going to find. And, joke, not a joke, serious, not serious, who knows, who cares. This is the perception now people have because of this post, this very, very inappropriate post going viral. Daniel Huckabee, a gentleman we'll talk about more later on in the presentation. I don't know if he still is, but at least at the time and for a while was the COO, Chief Operating Officer of Coyote Ugly, the saloons made famous by the movie where the women dance on the bars and sing and pour drinks and what have you. As part of his job at Coyote Ugly, he was charged with touring around the country to visit various of their locations to check on, compliance with standards, operations, what have you. And in one of their locations, he took this picture of one of his employees and tagged the picture with the line of his Asian American employee, my own little Asian sweatshop. One of my favorite examples, and you'll hear me say that a few more times during the presentation because some of these are just so good. Here you have on the left the Taco Bell employee, and we know he's a Taco Bell employee because you can see on the sleeve the Taco Bell logo. Posted a picture on Instagram from the back of a restaurant of him licking a stack of taco shells, and then on the right the photo he posted shortly thereafter where after he got fired for, after this post went viral, after he got fired for fired after the photo went viral for licking the taco shells back in the restaurant. And man, for some reason, fast food restaurants, I could have put in 24 examples of employees who do dumb things in fast food restaurants, from defecating on food to bathing in sinks, sinks back in the kitchen. Employees, for some reason, just in fast food establishments, just do the god awful stupidest things. Anyway, that's kind of the brand management risks. Let's talk about the legal risks, and the legal risks fall into, and that's what we're going to spend the rest of our time this afternoon talking about. The legal risks fall into what I call three really broad categories: kind of the risks that come from our discrimination laws or equal employment opportunity laws, risks that come from breaches of confidentiality, and then risks that come under protected concerted activity, which is a category of legal protection created and enforced by the National Labor Relations Board. And each one of these three gets some serious play in the world of social media. And so you look at the legal risks, and there are many, and the brand risks, and there are many, and you say, John, that's horrible. We want to do whatever we can to protect ourselves. Why don't we just institute why don't we just constitute a corporate ban, right? Why don't we just tell our employees, look, we don't want you on social media, period. Don't go on Facebook from work. Don't go on Twitter. Don't go on Instagram. Leave your phones, whatever. Okay. Number one, I don't think that's a workable rule for two reasons. Number one, because you're only going to impact what your employees are doing from the 9 to 5 that they're at work, number one. And number two, because you can install complicated server-side filtering software to block, Facebook and Twitter. You can put broad company policies in place that prohibit your employees from accessing these websites at work, and you can fire people that do. You can hire dozens of people to sit 24/7 and read server logs to see what your employees are doing on your systems, all of which is well and good, but all an employee has to do to circumnavigate those bans and those policies is pull their iPhone out of their pocket and go kind of off your grid, right? Go on their own personal grid and do the same thing that they would have done from their desktop or from their desk. When companies come to me and ask me the question of, John, why don't we just put a ban in place? The answer, as I talk through this issue with them, the answer I give them is, you're trying to pound a square peg into a round hole. This is not a technology problem. This is a performance problem. And if you, company, have employees that are not performing up to standards, then treat the performance issue. And if the performance issue, if the reason why they're not performing is because they're sitting at work on Facebook 8 hours a day, then that's a performance issue you need to address. But shutting down the technology, right, closing off the access on your network, all that's going to do is force them to find other means to do the same thing. So you're not going to solve the problem by treating a performance issue with a technological solution. Treat it like the performance problem that it is, counsel discipline. If it's out of hand, fire. But that's a performance issue, just like any other performance issue that you face in the workplace. All right, so with that out of the way, let's talk about what the actual legal risks are. And there's a bunch. And there's a bunch just under the one subheading of discrimination. One comes from what I call the Google background check, the kind of informal background check that companies do when an applicant comes in the door. They're considering hiring someone, and they go and type that person's name into the search bar in Google or into the search bar on Facebook, and they kind of see what pops up. What's wrong with that, you ask? Because there's a lot of good information we can discover. We can discover whether someone has ever licked a stack of taco shells or used the N-word or posted inappropriate photographs or if they've ever disclosed confidential information. All the things we looked at before. All the examples, great reasons why we might not want to hire someone, and how else are we going to find that information out if we don't do a Google search? Because if we ask them, hey, Erica Escalante, have you ever used the N-word? Yeah, she's not going to say yes. So how else are we going to find that out unless we conduct this, unless we run this Google search? Here's where that goes wrong. And I'll use a personal example from my own life to kind of illustrate the risk that's inherent with these background checks. My wife is now back at work. She went back to work a couple of years ago when my younger child, my 7-year-old son, now 7, went back to school. My son, who was born with a genetic condition called Noonan syndrome, and when he was 2 years old and he spent nearly a month in the hospital, it was actually over Valentine's Day kind of fell during his hospital stay. And so for Valentine's Day that year, I gifted my wife a blog. At the time, she was a stay-at-home mom, and I set up a blog for her so she could start writing and kind of sharing her experiences, my son's experiences, to kind of maybe try to do some, reach other moms, other parents that were going through the same kind of issues we were with our son and his the various medical issues that go with his specific genetic condition. And for a bunch of years, she wrote fairly regularly, and then when my son started school full-time, she then went back to work. And if a prospective employer Googles her name, they will find her blog. And if they find her blog, they will find out all about my son and his medical condition and the issues that we deal with that. And so now, faced with that, or with an equally qualified candidate, an employer is now put in the position of, do I hire the qualified candidate who has all this medical baggage, all of which is illegal to consider, Americans with Disabilities Act, Genetic Information Non-Discrimination Act, all of which is illegal to consider, or do I hire the other qualified candidate with none of those issues? And you're put in a position where you really can't unring that bell. And so what I counsel companies to do when they want to learn whether Erica Escalante has ever used the N-word, or whether employees ever posted a video of confidential information, is don't run the search yourself, decision-making hiring manager. Rather have someone either hire a third-party company to do it for you, or, because that gets to be expensive, train someone in your organization to run these searches, and then give the decision maker a scrubbed, sanitized report. Remove all of this protected EEO information, anything related to disability or genetic information or religion or age or sex or whatever. Get rid of all of that information and just give the scrubbed, sanitized report. that highlights the information that is legal to consider when you're making a hiring decision and doesn't contain any of the illegal information. And that way, if the decision is ever challenged, the hiring manager can, honestly and truthfully and in good faith say, I didn't know that, I have no idea. I mentioned genetic information. The Genetic Information Non-Discrimination Act, which makes it illegal not just for an employer to make a decision because of an employee's or their family member's genetic information, but also for an employer to take possession of an employee's or his or her family member's genetic information, actually contains a specific exception for the internet and social media, such that if you've been authorized by an employee to access information about them via the web, and you do so, and you inadvertently discover genetic information, you are absolved of any liability for as the employer, taking possession of information. You still can't make any decisions because of it, but at least you will be absolved of liability for taking possession of that information. So, using my prior example of my wife, and she'd be thrilled to know that I use her and her blog as examples in these webinars, I'm sure, but using her as an example, if the employment application for a job for which she applies contains language instructing that, we may run an internet search, and by signing here you signify that you understand and you authorize us to do so, under the Genetic Information Non-Discrimination Act, if whoever is running that search comes across this genetic information, that individual or that company will then be absolved for liability for the inadvertent discovery and then possession of that genetic information. Disability discrimination is another, not just in the information you can learn during these background searches, but maybe even one coworker disclosing confidential information about confidential medical information about another coworker. For example, you could imagine a situation where let me back up. So the ADA requires that medical information be treated as confidential, and employee medical information be treated as confidential, not be disclosed to other employees, and that managers and supervisors, basically only take possession of it on a need to, or it's disclosed to them on a need-to-know basis. Let's say employee has cancer, is out of work for a period of time. Supervisor knows the employee has cancer, is aggravated because he has to work extra hours to cover for this employee who is out of work undergoing treatments, goes on his personal Facebook page and vents by saying, I can't believe, I'm working so much, Jimmy better get back to work, stupid chemo, cancer, whatever. And I'm not making this up, this comes from a real case. And the company then, it gets back to Jimmy, maybe Jimmy's Facebook friends with the supervisor or other coworkers are, and it gets back to Jimmy that now everybody knows you had cancer, something you wanted to keep, we didn't know, something you wanted to keep private. All of a sudden now this company, because of this disclosure, is on the hook under the ADA for an unlawful disclosure of confidential medical information. And so, again, when I talk to companies about these issues, counsel companies about these issues, train, as I go into businesses and train employees on the appropriate use of social media, write social media policies for companies. One issue I always make sure I cover is to make sure that you are not using these tools to inappropriately disclose protected confidential medical information, because that disclosure is illegal under the ADA. Off-duty conduct laws, I don't want to belabor this point too much because it's not something we in Ohio have, but 29 states do have laws that say that if something is legal for you to do, an employer cannot fire you for doing it off the job. So two perfect examples, right? Smoking cigarettes, legal. Drinking alcohol, legal. If you're in a jurisdiction, operating in a jurisdiction that has one of these off-duty conduct laws, 29, almost 60% of the states do, you cannot fire an employee for engaging in this lawful off-duty conduct, and it's easy to see how this would come into play on social media. Take medical marijuana, for example, or even states where recreational marijuana is legal. You might not want employees working for you that smoke marijuana. You might discover an employee smoking marijuana by a photo the employee posts on Facebook. If you're operating in one of these jurisdictions, you cannot fire the person for engaging in that lawful off-duty conduct. And many times you're going to discover this off-duty conduct that you may want to take action as a result of through social media. One of the differentiating features of LinkedIn is the ability to provide recommendations for your connections on LinkedIn. You can actually go and write a nice little review about somebody, a coworker, a subordinate, what have you. Let's consider this hypothetical, I guess. Let's say employee's manager is connected with their subordinate on LinkedIn, goes onto LinkedIn and writes an amazing review of this person. Janie is the best employee I ever had working for me. She's as indispensable as both of my arms, and I don't know what I would do without her. I could not do my job without her supporting me, period. Send, there it is on LinkedIn. 2 weeks later, Janie is fired, right? And now let's say Janie is an African-American female over the age of 40 who's in a wheelchair. You are, pretty darn sure that LinkedIn recommendation is going to be Exhibit A in that supervisor's or manager's deposition in the ensuing race, sex, age, disability, discrimination lawsuit that employee is going to bring after the termination. Companies should have performance review policies in place and programs. If you don't have one, you should call me. I will help you get one. And they're there for a reason. They're there so that companies can control what's being said. In addition to the touchy-feely getting employees reviews and improving their performance and letting them know where they need to improve and what have you. But it's also so companies can control the message. And when managers and supervisors go rogue by posting these recommendations on LinkedIn, you lose control. And when you lose control, things like writing great things about an employee 2 weeks before that employee is fired happen. And you don't want to be in a situation where you have to defend that comment in a lawsuit. It's not going to turn out well for the company if you have to defend that recommendation in a lawsuit. And so, again, when I talk to companies about these issues, my recommendation on the LinkedIn recommendation is that you don't allow it and that you have a formal performance review program protocol and require that your managers and supervisors stick to that formalized process and not engage in this informal online these kind of informal online reviews. Harassment's another legal risk that's out there under the EEO laws. Harassment is what it is from a proof standpoint. Lots of harassment cases are he said, she said. I actually don't mind. Maybe that's the wrong way to put it, but it makes my job easier as a management side employment lawyer when I have a text message or a Facebook post or a tweet or something that I can look at where I can say, oh yeah, this guy really did say that or really did send that picture, Congressman Weiner. And now we know, right, the complaining employee is not making it up. We have the proof. And so from a does it make my job easier standpoint, in this aspect, it absolutely does, but it raises not just the question of harassment, but kind of how connected do you want your employees to be when they're not in the workplace? Because the extra levels of connectivity of managers to subordinates or employees to employees or what have you opens up avenues of communication, and the more communication you have, the greater chance that, especially hiding behind the anonymity of a phone or a keyboard, to say something inappropriate where somebody's going to feel harassed. This is my favorite example. I know I've said that before, but this one honestly truly is. You have this employee who goes on Facebook and writes as follows: "Oh my God." For those of you that don't know, OMG is oh my God. "Oh my God, I hate my job. My boss is a total pervy wanker, always making me do shit stuff just to piss me off, and as if she didn't make her point well enough the first time," in all caps with an exclamation point, wanker. What this employee forgot, however, was that she was Facebook friends with the pervy wanker who saw the post and then didn't need to comment. And he commented, "Hi, employee, I guess you forgot about adding me on here. Don't flatter yourself. You've worked here 5 months and didn't work out that I'm gay." I guess in response to the pervy wanker comment. And then he says, thirdly, that, quote, "shit stuff is called your, quote, job. You know what I pay you to do. But the fact that you seem to be able to fuck up the simplest of tasks might contribute to how you feel about it." And then he proceeded to fire her right there on Facebook. And look, I could talk for the rest of our 20 minutes, if not longer, about whether you should fire somebody via Facebook comment or a text message or an email. Spoiler alert, no, you shouldn't. It's a horrendous idea. But this slide illustrates the deeper point of, when you allow your employees to connect online via these social networks, this is the kind of risk that you're opening your company up to. And I'm not suggesting that we as employers tell our coworkers or tell our coworkers, subordinates, employees, don't connect via Facebook or Twitter or what have you, because every company is going to feel differently about this. Some are going to embrace the open communication, some aren't. It really depends on your company's attitudes towards technology, your level of risk tolerance, how connected you want people to be, whether how important you feel the engagement of your employee, the engagement boost of your employees connecting this way is. All that kind of gets thrown into the oleo, and out comes your organizational attitude about employees connecting online. I put this slide here only to illustrate the point that there is not one right answer for this. There's lots of ways to do it. In terms of no vertical reports can connect, nobody up or down, whatever. I mean, there's all different ways to do it. The point is that in an unregulated workplace, this is some of the risks that you are exposing you're exposing your organization to. And there's big generational differences in how employees feel about connections. There was a great white paper published by a professor at the Wharton Business School at the University of Pennsylvania, talking about all about the generational risks, the generational differences in social media. And a lot of what she wrote about was how the younger you are, the less comfortable you are with your manager at work sending you a friend request on trying to Facebook friend you. She referred to it as the creeper factor, that the younger you are, the more creepy you think it is that your boss is trying to be your friend on Facebook. And so there's generational differences that come into play here as well. The FMLA is yet another risk. While it's technically not discrimination, it kind of falls under this kind of umbrella of laws that federal laws that regulate the workplace, and so I kind of have it here. This is an actual exhibit from a summary judgment motion filed by an employer. The employer was a hospital in Detroit. The claim was brought by a nurse who was out on FMLA leave, and the company said, "We think your FMLA leave is fraudulent, and we're firing you." And why did they think her FMLA leave was fraudulent? Because they found on her Facebook page, again, one of her coworkers ratted her out, found on her Facebook page photographs of her doing all these things on her Mexican vacation, which seemed to suggest that maybe her back wasn't quite as injured as she said it was. Most tellingly, the photo in the upper right of her riding the speedboat. Maybe you don't really have a back injury or one so bad that you need to be off work for 12 weeks if you can gallivant around Mexico getting drunk and riding speedboats. And the company won this case on summary judgment, purely because solely because it had this evidence showing that the employee's FMLA leave was in fact not a legitimate use of the statute. And lastly, retaliation. We talked before about Coyote Ugly, Daniel Huckabee, and the Asian sweatshop. Coyote Ugly, shortly after Daniel Huckabee posted that photo, was sued in a nationwide class action wage and hour lawsuit, saying that they weren't paying their bartenders and servers their tips properly. And that lawsuit then spurred two separate retaliation claims by two different employees. This was a blog post that Liliana Lovell, the then CEO of Coyote Ugly, wrote, where she took issue with one of her employees filing the wage and hour lawsuit and making some, not serious but nevertheless some threats against the employee in this blog post. Similarly, Daniel Huckabee, our Asian sweatshop friend, on another tour of one of their bars, was sitting at the bar one night, by his own admission, had a few too many drinks, looked across the bar, saw one of the named plaintiffs in this wage and hour lawsuit, took his phone out of his pocket, went on Facebook, and typed into Facebook, his status was, "I'm going to kill the bitch that's serving me drinks that's also suing my company." Or I'm paraphrasing, but that was the sentiment. Kill the bitch is a quote. Both spur retaliation claims because of the comments that were written in social media. Very important if your organization is involved in litigation, not to go on social media and comment. A, it becomes evidence in the case. B, if you're writing unsavory things about the plaintiffs, the people that are suing you, very real risk that those unsavory comments have the potential to spur a claim for retaliation. The next legal risk is confidentiality, and confidentiality in my mind comes in two different flavors. Number one, we think of kind of agreements not to compete, agreements not to solicit, and there's been a whole bunch of cases that have been filed around the country in which employees that were barred from going to work for a competitor or barred from soliciting customers of their former employer, where the company tried to say things like merely maintaining the fact that you maintain your connections on LinkedIn, or the fact that you updated your Facebook status or your LinkedIn status to show that you now have a new job working for this competing company, in and of itself violates the agreement not to solicit or agreement not to compete. And universally, courts have rejected that argument. Courts say that solicit, whether it's directly or indirectly, requires some showing of intent, and merely, changing your LinkedIn account to show that you have a new job where you may be connected with customers is very different than sending someone an email or a message saying, "I'm now working for this company. Please buy from me, not from my old employer." So universally, courts have rejected that argument, and I suppose that I guess there's an argument to be made out there that if the agreement is written a certain way, an employer is gonna, and the case is out there. I haven't seen it yet, but it's out there, and we'll see it soon, I'm certain, where the employer has an agreement and says, under the terms of this agreement, we own all of your LinkedIn, connections, and once you leave the company, you need to disconnect from all of those people that you were connected with. No court's ever gone that far. Whether a court will, I think, remains to be seen, but is nevertheless an issue that is worth watching. The other issue that falls under this area of confidentiality raises the question of kind of who owns corporate social media, and this really touches on when you have a corporate branded social media channel and you have employees that are charged with maintaining that account, tweeting for you, responding to people on Facebook or posting content on Facebook, writing a blog, whatever. Kind of what happens to that account when the employee leaves? The most famous case involved PhoneDog, and Noah Kravitz. Phone Dog, and this is an actual piece of litigation. Phone Dog is a website that writes reviews about cell phones. Noah Kravitz, when he worked for Phone Dog, was responsible for maintaining a Twitter account under the handle @PhoneDogNoah. Noah Kravitz left Phone Dog. He was the only employee that knew the password for the Twitter account. He left Phone Dog, and immediately upon leaving, changed the account from @PhoneDogNoah to @Noah Kravitz, refused to give Phone Dog the Twitter account back. Phone Dog went into federal court in California and sued Noah Kravitz, saying that you not only stole our property, but stole our trade secrets, the trade secrets being the identity of all of our Twitter followers. That argument failed. There's nothing more public than Twitter. It's not private at all. In order for something to be a trade secret, it actually has to be secret, and so that argument failed. But in terms of who owned the account, they went 10 rounds in court and ultimately settled after both sides spent an ungodly amount of money because there was no agreement between the parties. And the court had to dig into things like Twitter's terms of service to try to get some guidance on who owned the Twitter account. Believe it or not, Twitter's terms of service say we own the account, so that wasn't any help. But if you have corporate branded social media channels and you have employees that are using them for your business, the best thing you can do is have those employees sign agreements that define the ownership rights of that social media, so that when an employee leaves, if or when an employee leaves, you're not getting into arguments over, what do Twitter's terms of service say over who owns the account, because you are going to have it defined on a piece of paper that your company owns the account, not the individual who's tweeting for you, which in turn makes it much easier to go into court and get ownership of that account given back to you if an employee goes rogue, leaves, and on the way out the door changes logins and passwords so that you no longer have access to the account. The last category I want to talk about deals with protected concerted activity under the National Labor Relations Act, and this is an area that the NLRB, the National Labor Relations Board, has gotten extraordinarily active in. Has been active in this area for at least 5 years. Real kind of 40,000-foot picture of what protected concerted activity is. The National Labor Relations Act, which is the law that governs the relationship between labor unions and employers, says that whether you're in a labor union or not, all employees, unionized or non-unionized, have the right to engage in what's called protected concerted activity, which is the right to talk between and among themselves about wages, hours, and other terms and conditions of employment. What does this look like in the social media world? Let me give you two examples. Example number one of how employers can get themselves in trouble for disciplining or firing employees for things they say or do online. So example one deals with a car dealership in the Chicagoland area. They sold BMWs. Had a commissioned salesperson who was displeased that the dealership was announcing the launch of a new line of BMWs with a carnival event in the dealer's lot. They were going to have clowns and balloon animals and a hot dog cart with hot dogs and bags of chips and bottles of water. And this salesperson went on Facebook to complain, went on the dealership's corporate Facebook page and wrote a complaint to his manager saying, look, I think that this event is hokey, it's beneath the status of a BMW, and it's going to make it really hard for us to sell cars if people are so turned off by the kind of hokiness of this event. All right. Flash forward a week, the BMW dealership had a sister Land Rover dealership across the street, and this Land Rover dealership had a really, really good customer whose 13-year-old son wanted to take one of their Land Rovers out for a ride, and so the manager of this dealership, the Land Rover dealership, not wanting to upset his really, really good customer, gave the keys to this 13-year-old kid, who proceeded to quickly roll the car into a ditch. The same salesperson, the guy who went online to complain about the bottles of water and balloon animals, took a picture of this upside-down Land Rover and then posted a picture on his personal Facebook page. Some of his coworkers with whom he was Facebook friends thought that was in bad taste, printed it out, gave it to his manager, who then fired him. He filed a charge with the NLRB, and the NLRB ultimately said, we're dealing with two different things here. Your comment about the promotional event absolutely protected concerted activity. You're a commissioned salesperson. You had concerns about how losing money because you were, if you weren't selling enough cars. You're complaining to your with your coworkers, to management about wages, terms and conditions of employment. Absolutely protected concerted activity. But Mr. Salesperson, that's not why you were fired. We think you were fired, and what motivated the decision to fire you was the photograph that you posted in extraordinarily poor taste, and therefore, Mr. Salesperson, you lose. I like using that case as an example because it kind of gives a nice illustration of what protected concerted activity is versus what it isn't. Complaining about wages, hours, terms and conditions of employment, the sales commissions versus a tasteless photograph of an upside-down car, protected, not protected. Another great example to see kind of how far the board is going here involved a sports bar in New York, in upstate New York, where you had some employees going on Facebook to complain about not being paid properly. Those employees quit, but they were still Facebook friends with some people that still work at the bar. So you have an employee, former employee, writing about how cheap management is and they don't pay wages right, they don't tip out correctly. And you have an employee who doesn't do anything other than click the like button underneath that post on Facebook. That employee is then fired. And the NLRB, all the way up to the Federal Second Circuit Court of Appeals, concluded that even the mere act of clicking the like button is enough to raise the specter of protected concerted activity under the National Labor Relations Act. It's just really quickly, and then we'll wrap up with what the board is doing with social media policies. Unions have gotten very, very active in this area as well. Unions have recognized that these social websites provide a great tool for them to organize employees, and unions are actively using things like Facebook and Twitter to get information to employees, gather information from employees, and try to organize employees. The other area where the NLRB has gotten really, really active is dealing with what they view as overly broad social media policies. And the NLRB has written 3 different policy papers, and in decision, one after another, has struck down a variety of what I think of as very garden variety kind of workplace policies and employment handbook policies that have nothing to do with protected concerted activity at all. A policy that I see a lot in the handbooks when I review handbooks that does have to do with protected concerted activity that is absolutely illegal is a policy that says something like employees can't talk about their wages with one another, and if you do, you're subject to discipline up to and including termination. 100% illegal because you have a policy that is chilling employees' right to talk about wages between themselves, protected concerted activity. What the NLRB is doing is reaching much more vanilla, much more garden variety policies, things like be courteous to your coworkers, or you cannot, it's a violation of company policy to use the company logo without permission, things like that. The NLRB has taken the position, let's use the be courteous policy. The NLRB takes the position that, employer, no employee is trying to organize you right now. There's no union that's out there that's trying to organize you. But if a union did, 1,000,000 to 1 chance to try to organize your business, union organizing campaigns often become nasty and dirty. And a policy that requires employees to be courteous to each other, an employee in the realm of this hypothetical union organizing campaign might presume that that policy limits their ability to be discourteous to someone that is anti-union or express their feelings about management in the heat of this union organizing campaign. And so we find that that policy, because hypothetically maybe million to one someday somebody might read that to prohibit them from saying something, is overly broad and overly restrictive. There are, if you have interest in this, I can do a whole hour just on, and maybe we'll talk about whether this is a good topic for another session, but kind of handbook policies in the wake of what the NLRB is doing in this area. But I commend to your reading. You can go on nlrb.gov, the NLRB's website, and you can pull up their general counsel's report on employment policies and this third report on social media policies, which are 50 or 60 pages in depth, talking about the variety of what we really think of as garden variety handbook policies that the NLRB believes, all of which across the board just about are unlawfully overbroad. So that takes us back to where we started, which is Heather Armstrong and her advice for employees: be not so stupid. Again, if employees heeded this advice, we wouldn't have been talking today. I probably wouldn't be. An employment lawyer, one social media policy that I can wholeheartedly endorse, and if you ask me, John, could you write a social media policy in 4 words? I could, right? It's just this. It's just think before you click, right? That's the policy in its most simplest terms. Because if you don't, employees, this is ultimately for employees who don't think before they click the consequences. I thank all of you for joining us again today for Take 2. I'm glad to see it went off without any technical hitches this week. You have in the slide deck any information, or my contact information rather, should you have any questions for me. I am not hard to find. If you Google me, you find my blog, you find my Twitter. I'm all over social media, which is why I love talking about this stuff. But I write about this stuff, every day on my Ohio employer law blog. The hyperlink, the URL for which you have here. You can find me on Twitter, on LinkedIn. The blog has a Facebook page as well if you prefer to interact and get information that way. I don't hide. I'm easy to find, and I'm happy to chat with anybody offline about these issues or what's going on in your particular business. So with that, I thank you all for your time today, and we'll see everyone again for our next webinar in 3 months. Thanks.
Thanks, John. Just a couple reminders before we get to any questions that we have. This live webinar is eligible for 1 general recertification credit through the HR Certification Institute. Make sure you do the survey at the end of the webinar, and we'll email you the certificate later this week. And the webinar has been recorded, so we will send a link to it to everybody who has registered for it, and it'll also be on our website. Do you have time for a quick question, John?
I certainly do.
Okay. One of between the U.S. and Europe, they actually have the right to be forgotten as part of their privacy policies. And as far as the internet, Google searches, things like that, do you see anything like that ever coming to the U.S. or being part of our policies? Or
I don't see it coming here. For those that do business internationally, it's something to consider and keep in mind that the right to be forgotten does exist over in the EU. It doesn't here, and whether it's First Amendment issues here or it's it's just not the privacy. Europe has a much different mindset towards privacy than we do here, and it's just I don't see that as being part of our cultural mindset that the right to be forgotten is going to come over here at least anytime soon.
Okay. Thanks. It looks like that's going to be all of our questions for today. We look forward to seeing everybody again in April. We'll be doing another webinar, and stay tuned for information on that. So thank you to everyone for joining us, and have a wonderful day. Bye-bye.